Really, I covered three areas of damages. The first was I took people through the customary international law framework for damages at international law and tried to explain when the situation arises where you can claim loss. And I focused in particular on the importance of proving that you have suffered a loss, so the causal link, causation, which is a very interesting issue. And then the other two parts of the damages analysis I looked at were the emerging areas, which were contributory fault, which is a familiar concept to many of us, but is just starting to take hold in investor-state arbitration, and we're seeing some decisions come through with some element of that now, 2 or 3 in the last few years that are quite interesting. And the final point I looked at was moral damages, which for the same reason, it's coming through now in some of the more recent decisions, and there was a concern I identified about whether or not that was developing in a principled way, and I flagged the concern and said that I think we had to be very careful with these new emerging areas to make sure they develop in a principled fashion so that they are applied properly. So those are the three areas of damages I dealt with. The second part of the presentation dealt with interest and costs, which are often left off as an afterthought, but are actually quite important areas, especially for practitioners and clients, can have a very significant impact on your total amount of loss. And I just ran through the basic framework and highlighted a couple of trends that are coming through in tribunal decisions where we can see them, so that I could show the audience, look, if you are arguing about these issues, this is the way that the majority of tribunals are now looking at these issues, and this is the way they're ruling.